Good afternoon, everyone. Welcome to our program today entitled Top 10 Risks Facing Nonprofits Operating Internationally. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. And this program is part of the monthly series that we've been doing for over 6 years now on a wide array of different nonprofit legal topics. We're really excited about today's topic. We have a terrific panel that I will introduce to you in a moment. But let's go over a few housekeeping things first. First off, this program is being recorded, and the recordings of all of our monthly webinars can be found on our YouTube channel, a link to which is on the last slide of today's PowerPoint presentation. We have a great crowd here in our DC office that joined us for lunch, and we have about 250 people signed up for the webinar across the country. First off, for those of you from the trade and professional association community, these programs are eligible for continuing CAE continuing education credit. Preview of our upcoming programs. On January 12th, our program is entitled Top 10 Hot Button Insurance Issues Facing Nonprofits. And on February 2nd, our program is entitled, again, common theme here, Top 10 Cybersecurity Tips for Nonprofits Managing Your Technical and Legal Risks. Both should be terrific programs. And then after the February program, we move to our new home. Our new office is up the street, and starting in March, we will be doing our programs from our new offices. I hope you can join us there. We have a very, so for those of you in the room today, you have a handout booklet that contains printed copies of the PowerPoint deck along with some related articles in the back of the book and full speaker bios. As you can see, we have a very dense PowerPoint deck today. There's a lot of information to cover, so bear with us as we work our way through it. And we are going to have to ask you to hold your questions until the end. Unless you have a really burning question, wait until the end and then raise your hand, and someone will come to you with a microphone so everyone on the webinar can hear you. For those of you on the webinar, pose your questions to me using the chat feature of the webinar software. Those of you on the telephone received a link to the PowerPoint slides in the confirmation email that you received this morning. So our speakers. We have 3 speakers, 2 of whom are from Venable, and 1 of whom is from the co-sponsor of today's program, which I should have announced at the outset, BDO. BDO is a terrific accounting and consulting firm. We work closely with BDO in a wide array of capacities, share many common clients, and we're fortunate to have one of BDO's partners here with us today. But first, to my immediate right is Anita Drummond. Anita is counsel in our nonprofit organizations practice here in Washington, D.C. She's been with us only a few months so far, but I've worked with Anita for maybe the better part of a decade. She worked at the Nature Conservancy most recently as Deputy General Counsel for quite a number of years, and prior to that at another organization we worked together with Associated Builders and Contractors. And Anita, especially through her work at the Nature Conservancy, has extensive experience working with nonprofits operating internationally, and has some great insights and other valuable information she's going to share with you today. To Anita's right is Carrie Kroll-McMullen. Carrie is a key member of our international trade practice here at Venable. I've worked with Carrie for how long now? 9 years. I'm going to say it seems about a decade. Carrie is absolutely terrific. She's been kind of our practices, our nonprofit practices, go-to person in kind of the international trade and regulatory space. A fantastic lawyer, has worked with dozens, if not hundreds, of nonprofits in connection with their overseas activities. And Carrie has, I'm really pleased that she's on our panel today. And finally, last but not least, to Carrie's right is Matt Cromwell. Matt is an assurance partner at BDO. He's been with BDO. He has extensive experience performing audits and providing accounting and consulting services for nonprofit organizations. Matt joined BDO in 2009 after 15 years with Ernst & Young. Matt works extensively in the international space, the international NGO space, is a wealth of incredibly valuable information, and we were very fortunate and very pleased that he's willing to join us here today. You can take a look at full speaker bios in the handout book. So without any further ado, I'm going to turn it, actually, sorry, one more thing to announce to you. We announced this at our last monthly program a couple weeks ago, but Venable just launched, thanks to, particularly to my colleagues Diz Locaria and Melanie Topman in our Government Grants and Contracts group, a new Government Grants Resource Library. This is really their brainchild, but we've all worked on it for quite a number of months now putting this together. It's a terrific resource of all sorts of laws, regulations, articles, tips, suggestions, kind of anything and everything you want and need to know in the government grant space from a legal and regulatory and accounting perspective. I think you'll find it to be a terrific resource and encourage you to take a look at it at grantslibrary.com. Now, without any further ado, let me turn it over to Anita to get us started.
Thank you, Jeff. Thank you all for coming today. It's interesting, this particular presentation says the top 10 risks, so we want to emphasize you're going to come away with the top 10 solutions as well. Nothing worse than hearing someone tell you all your problems without your solutions. The top 10 risks we're going to talk about is making sure that you know when you are in a country and that it does require some sort of authorization. Some of the baseline requirement questions, every country is going to vary. We're going to talk about poor partner and contractor selection and what risks that will take, inadequate controls over corruption in your operations, rogue employee approaches, some key things to think about whether you are engaging employment in the country and what implications that has for you. Matt's going to particularly focus on how to limit your how not to have limited financial controls, how to address that, and how to better meet the expectations of funders, particularly institutional and government funders. Carrie's going to address how to protect your intellectual property and to put more controls through contracting. And last but not least, I'm going to hit on taxes and insurance. So as with every risk, you do need solutions. So we hope you walk away feeling like you've got a little bit of a parachute today. So first thing I love working in-house, particularly over the years, the staff think they're not there. We're not in that country, but they love to talk about how they're in that country. We're collaborating, we're partnering, we're doing a lot of things. Well, you are here is something that every organization should know when exactly you are there enough to trigger legal requirements. So it's important that you think about the countries that you have staff visiting. What activities are they engaged in that are triggering different kinds of registration requirements? It's so important to have a good sense of the scope of those activities, whether it be what it actually is or how much time and who are the people that are going to that country. Determine what is short and long-term activities. And what I mean by that varies by country. We'll touch on that as we go through. But a good example is you may have nothing but employees going in and out of a country, but they've accumulated enough hours, enough days in that country to trigger employment taxes, which then requires you as an organization to register in that country if solely for that purpose. It's that kind of triggering that you as an organization benefit by knowing and controlling for to the extent that you can. You want to identify what human resource needs your organization has on the ground, because by knowing what the definition of what here is, you can decide what are the best ways to bring those resources to bear. Is it really employees? Can it be done through grants to partner organizations who are already on the ground? Is there a mechanism to hire contractors on the ground without triggering additional requirements? So I think having really deep discussions about what humans are needed and then where those humans might be sourced from is a good way to identify what is your organization's comfort level for being in a country. A lot of organizations go to countries with an expectation of bringing in new revenue sources. I would say in almost 100% of the cases, that's going to trigger the indication that you are in that country. You are there and you will need some type of registration. Determine what kind of expenses you're going to have in the country, and do they trigger special registration or licensing. It's always good to sit down and say, depending on our organization's different levels of activity in various parts of the world, what are the legal experts we really need to have aligned with us, who have a deeper understanding of us, that can answer more quickly what it is we can and can't do in countries, or what kinds of liabilities. So the very first question you always have to ask is, are we here? So the definition of doing business does vary greatly, and I've already mentioned that. But there may be different legal forms within a country. Many people say, well, we're just going to open a branch there. Many countries, that's either not a viable option or a very expensive option because it triggers different types of tax implications. I will just mention one very close, near and dear to heart is just Canada. We're just going to open a branch office in Canada. Canada has extraordinary penalties for simply opening a branch office, so you have to evaluate the different legal forms. And those forms more than likely will not be parallel to how you're operating in the United States. A nonprofit may mean actually having no profit. If you're a charity, there may be absolutely no tax advantages to donors in that country. So having a very good sense of the different legal models in a country is important, and what legal controls there should be on the money. Carrie, would you like to comment on that?
I would. And I would just add, because I get this question all the time, when you're looking at the different opportunities, different types of legal forms in a country, don't be surprised if the one that looks like a charity isn't the one that ends up fitting best with your model in that country. Oftentimes, charities or social enterprises, as sometimes they're called, especially in countries in Southeast Asia and in South America, are for very discrete types of activities in that country and don't match up well with the nonprofit definitions of an entity here in the United States. And so you might end up being in the sort of model in a foreign country that looks more like a for-profit business type, but you can still conduct, with the proper legal advising, the types of activities that you'd want to in that country. So I just add that point.
That's a very good one, because poverty is frequently one that, if the country does have a charity status, that's what it sees. In the United States, we have many, many ways in which to be a charity. And as Carrie said, you just don't fit in that country's view of a charity legal form. So I think a very important part, in which we'll talk about much more, is money. How money is coming into the country to operate, how money is spent in the country. All these things will trigger a question of, do you have a legal presence that requires special registration? It's very important to take a very thoughtful approach to a country in which you've never worked, and taking a phased approach is often the best. Ways to get money in the country to parties that have aligned interests to you, doing grant making, having short-term events, working possibly as secondment, having people work for another entity in the country, using association management companies. And I will make a comment to Carrie's point, just charities sometimes don't realize they can fit into an association management organization. They do not have to go in as a charity, and they sometimes overlook that. Are there contractors? Is there ability to contract in country? Or does that trigger other requirements you're not comfortable with? Are there joint venture? Can you work with the government there? Many times governments are very interested in what you have to offer and may enter agreements to waive many of the normal requirements. And then there's the full-on creating a branch or a new entity. And finally, I will say, I emphasize to keep good counsel. This is not just because I'm a lawyer, but because of my experience over the years, even before I became a lawyer with nonprofits. Not having someone who's really grounded in the common issues that come up and have local counsel that's being managed appropriately, knowing how to ask the right questions, can really facilitate the conversation. They don't know that you don't know what a nonprofit is in that country. Having a very deep understanding of the questions and also knowing how to document the scope of what you're going to do. Keeping good counsel helps you over time as circumstances change. So I can't emphasize enough, knowing whether you're there may take some very good counsel.
Sorry. So the next thing that we're going to be discussing is the review of who you're partnering with or contracting with in the country. Oftentimes, as Anita went through, it's important to look at the opportunity to do a phased approach into the country and your activities there. And many, many times that includes working with a partner or an agent or a contractor in the country, or a similarly situated organization or association in the country. And so what we want to talk about next is the basics, the due diligence that we would recommend you undertake prior to engaging with this partner, this agent, this contractor. Who is it? What's the legal form of this potential partner? Who are the controlling individuals? Something that we'll talk about a little bit later is the compliance recommendations that we would have with respect to screening and looking to make sure that you're doing business with people that are not corrupt, that are not part of a terrorist network. And outside of that, just basic illegal, corrupt activity, just what is their reputation? Is it a good one? Do they have a reputation of doing the type of work that you're looking to do and doing it well? Maybe they're a more general association and you are looking to do something that's more specific. Looking at local references, the internet has a lot of good stuff on it these days, but cross-checking that with people that you may know in the country. As Anita said, Counsel may be a great resource for looking at reputational concerns and due diligence in that respect. What is their expertise would be the next thing, and is their expertise commensurate with what you're trying to do as far as the size of your activities, the frequency? Are they great at putting on huge trade shows, or has their expertise over the past few years really concentrated more on smaller networking events? And how do they operate currently? Do they have a network of agents? Oftentimes we have questions that come to us that say, we identified this great partner in a country, and they've told us, well, we work with 4 or 5 different subcontractors. And we don't know anything about the subcontractors, but we are now already sort of engaged with this partner, and that makes us nervous, and that makes us nervous too. And so knowing how they operate ahead of time, are you going to be working with people in-house at that entity, or are they just going to be passing it on, is a really important one. What's their capacity? And who are the people that they have on the ground? And importantly, as we have in bright red up there in the corner, is ask for these records and maintain them in some sort of written format, whether that's electronic, you get it through snail mail, anything will do, and keep hold of those. And this is for purposes of protecting yourself and being able to later on down the road say, you know, I have a first line of defense should there be any investigation or inquiry, but also making sure you keep a cross-check on who your partner is. You told me this last year. Let's talk about it. And with that, I'll turn it over to Matt.
Thanks, Carrie. And certainly from a financial review standpoint, what we want to look at is it really an entity? One of the things that always scares me when we're going through some of these projects is you ask simple questions, do you have audited financial statements? And they give you a look of, well, yeah, we did it 4 years ago. You know, you're overseas, do you have any type of time reporting? Well, why would you do that? How many different organizations contribute to the organization? What type of subgrantee monitoring are they used to having? One that I think back on very interestingly was tax management side. And I'm not a tax guy, by the way, but from a tax management, they'd never filed taxes in the country. They'd never done any of their Social Security taxes in the country. And so the organization really wanted to do business with this entity. And we kept saying, this is not an organization that you want to do business with if they're not doing their basic blocking and tackling as it relates to tax filings and making sure that they're doing what the government says, because it can get you into a lot of trouble. You know, third-party compliance, the uniform guidance we all know is now out there, certainly being implemented by a lot of you. Do they have any type of compliance type work in their background? I think for certainly larger international NGOs especially, you want to make sure that they're going to be able to comply with what you need for all of your subgrantee monitoring, and that takes a lot of documentation, which frankly a lot of subgrantees overseas don't have. And then finally, here in the U.S., are they financially viable? I have an organization right now over in Alexandria who's dealing with its immigration and refugees. And certainly with all of the noise around our November 8th, and I'm sliding this, are they financially viable? What are they going to do come January 21st? And so there's a lot of questions that you should be asking over vetting your partners and your contractors. Can they actually perform what you need them to perform? Bottom one. Okay, there we go. There we go. So as Jeff had alluded to, I'm overseas quite a bit of my life, and ones that we often come into are the large regional district hospitals, or whether it's a small mother and child clinic. You want to give money, you want to help these people, you want to do it, but how are you going to be able to support what you need to keep yourself out of trouble? And that's sort of what I always tell my clients. Do what you need to keep yourself out of trouble first, and then sort of move on from there. And we'll go through the financial controls a little later. But it's vital that you don't get yourself pigeonholed into a situation where you're going to wind up with legal ramifications. And to what you both said, having the appropriate legal advice in place is critical. I can't support that enough from the assurance side of it.
And so the next solution that we are going to discuss is to raise, and this is not to make you an expert, but to raise and provide an overview of some of the U.S. regulatory concerns and compliance concerns that should be foremost in your thoughts as you are looking to set up overseas operations or enhance the ones that you already have in place. And again, this is not to make you an expert, but as both my colleagues have said here, it's to provide a first line of defense, keep yourself out of trouble as you're looking to do business overseas. And I will preface that the next 6 or 7 or so slides I won't go through in great detail, but should be a resource for you going forward. These are 3 different statutory frameworks, and I think each could have its own presentation. The first one that I'll recommend, or that I will discuss, is the U.S. Foreign Corrupt Practices Act. Many of you have probably already heard of the FCPA. You may be very familiar with it. And depending on the type of operations that you do overseas, it may be more important to those operations or less. The FCPA is a law that's a U.S. law. It's been in place since 1977 and is pretty specific in what it prohibits, which is to bribe a foreign government official. The anti-bribery provisions are the ones that we will focus on today. There are 2 big sets of provisions under the FCPA. The anti-bribery provisions, they touch everyone. Anyone who is a U.S. entity, U.S. person, a U.S. concern, that is someone who is an entity that may be traded on the stock exchange. There's a second set of provisions that we won't discuss in detail today that are called the books and records provisions. But I mention them because they basically say keep accurate and contemporaneous books and records. It's really important to do. And oftentimes when we see a DOJ investigation in parallel or standalone with the SEC, one of the first things that is in that press release or that case report is there were not good records that set out what this entity was doing abroad. And so while we don't discuss those in detail here, we would say that one of the most important recommendations we can make with respect to compliance with the FCPA is write it down. If you are in a position where you're providing something of value to someone who may be or is definitely a foreign government official, write it down. Write the date, write the amount, write the purpose. Those records are the most important thing that you can do. So the anti-bribery provisions prohibit the paying of, offering, promising to pay money or, quote, anything of value. And DOJ has taken that anything of value and made it quite broad. And so this really is more than just, passing on the briefcase of money that you see in the old mafia films. With corrupt intent, directly or indirectly, and this is what brings us back to the very important point with respect to our agents, our contractors, or our partners abroad. This can happen as long as it's on your behalf. This can happen through a third party. to a foreign government official, again, very broadly interpreted to mean anyone at any level of that foreign government, or their relative, or their best friend in certain scenarios, or a political party official for the purpose of influencing an official act or decision, causing one to be failed to perform, or obtaining or retaining a business advantage. So all of these are important aspects of those anti-bribery provisions, and ones that you can use as a resource when you're trying to sort of understand when this may come up. And so nonprofits are not exempt, and we've seen this in case law as well as advisory opinions that are issued by the Department of Justice, and those are like when an entity might come in and say, I've got a feeling this might be right on the line. DOJ, can you tell me whether or not that's true? We saw an advisory opinion issued by DOJ a couple years back where an entity wanted to go in and donate a bunch of heart rate monitor type machines to a hospital in China. And they said, can we do this? And the Chinese hospital ended up being this entity, this U.S. entity happened to be in the pharmaceutical business, and this Chinese hospital ended up happening to be on the other side of looking for, I don't know, some heart rate machines and different related medical devices. So the Department of Justice said, if you're going to do this, you better put a couple things in place before you do. Keep records of everyone you give it to, because in this case, the hospital was owned by the state. So talk about that broad definition. Make sure that as a result of this, you're not getting or retaining the opportunity to get a contract. And so it can be broad. It can be more than, like I said, that briefcase. Who is the foreign official? Just keep in mind, looking at your opportunities abroad, if you're working with schools and universities, it's a lot of times where this comes up. Schools may be state-owned, or a lot of times they are state-owned, and so even a professor at a school might be seen as a foreign government official. And like I said, this agency relationship that's going to happen directly or indirectly. And then finally, we bring up that there are other national and international laws that apply here. The FCPA used to be the big bad anti-bribery law in the world, and for many years U.S. entities would complain and say, this isn't a level playing field. Nobody else is subject to this but me, and so they all get to bribe the guy down the road, and I'm stuck with my hands in my pockets, and I don't get the permit, and everyone else does. That's not the case anymore. And in fact, most foreign jurisdictions where you might be doing business, believe it or not, including Brazil, China, India, these places all have local anti-bribery laws. Two that we point out that actually are more broad than the FCPA is the UK Bribery Act. That prohibits not only this public bribery, so bribery of a foreign government official, but private as well, commercial to commercial. You can't bribe the business down the road or the guy down the road as well. And then the second, we just point out the OECD, the UN Convention, actually has a broader definition of what bribery entails, so also encompasses that private bribery, and prohibits what are called facilitation payments, which are small, discrete payments that are still, they're sometimes referred to as grease payments, that are still considered an exception to the FCPA. And so looking at these more broad, potentially broad local laws as well as international conventions when you're going abroad is really important in understanding what your own sort of compliance guidelines and baselines might want to be. So the next thing that we'll touch on, and again, not to make you an expert, this is going to be at this high level, are what are economic sanctions and what are export controls? These are two sets of regulations that apply to U.S. persons. And U.S. persons, as we set out here, is quite broadly interpreted. Any organization or group established in the United States, incorporated in the United States. Again, nonprofits are not exempt. Very, very briefly, U.S. export controls, those are the controls and the licensing requirements that may be applicable if you're sending U.S. origin goods or things from the United States out to your partners and your entities and your operations around the world. Most often, the question we have here with nonprofit operations is, I want to send a bunch of computers to set up my office in X country. And we got this great deal. We have a contract with Dell here in the United States, and we'd like to do that. Well, that may require a license. And it's an inadvertent mistake, but one that will find yourself on the other side of looking at the Commerce Department probably providing what's called a voluntary disclosure and obtaining the appropriate licenses. And then the only other thing I'd say there is even if it's not something like a computer, depending on where you're doing business, this sometimes comes up. Unlike for-profits, nonprofits might be operating in a place like Sudan, where the United States maintains controls, even if you're sending a bunch of notepads. And so you'll want to make sure that depending on where it's going and what it is, do you need a license? Is that something that we need to look at? And then finally, we'll talk briefly about U.S. economic sanctions. And these are the controls, the embargoes that you see front page of the New York Times, the Wall Street Journal every day. This is Iran, Cuba, Syria. And sanctions are the prohibitions that the U.S. government puts on the ability of a U.S. person or entity to transact business with persons or entities in these countries or with the countries in general. These are comprehensive embargoes in certain respects. We'll talk, Syria is an example of that. And some are more targeted restrictions. And so you may be doing business in countries like Libya or Lebanon or Sudan or South Sudan even. While there are not blanket prohibitions on doing business in those countries, what's very important is to screen who you are doing business with, both at an individual level and at an entity level, because they might be what's called a specially designated national, in which case, as a U.S. person, you're not allowed to do business with them. So just a few important principles here. These are sanctions that are implemented by what's called the Office of Foreign Asset Controls, or OFAC. They're all unique. Not one size fits all. As you may have been tracking over the course of the last year or so, our Cuba sanctions have changed dramatically. You used to not be able to step foot in that country. Now you can do a lot of different things, especially in the not-for-profit sector. They change frequently. Cuba is a great example of that as well as Iran. A couple months ago, we had sanctions against Burma or Myanmar. That doesn't exist anymore. That program is now gone. The Office of Foreign Assets Controls revoked all sanctions against Burma. And these may overlap if you're doing business with a partner and entity in the EU. They may overlap with some of the restrictions or prohibitions that your EU partner also has. So don't feel like you're going in and you're the only one with these potential prohibitions or compliance concerns. Most of the Western world is dealing with similar ones with respect to some of the big ones like Syria and Iran. And Cuba, we're fairly unique still, but North Korea is another example.
Carrie, can I ask you a question?
Of course.
Carrie, you mentioned both entities and individuals. So if an organization is dealing with a partner that is a company, are there individuals within the company that you would recommend that they look to, not just the company?
That's a great question. And this probably overlaps with some of the controls that you have on funding and subgrants as well. You want to look definitely at the entity itself, and then the person's controlling or owning that entity to the extent that information is available. We'll talk a little bit about what due diligence questions to ask. And one of the most interesting things I always find when we're sort of on the other side of this is, well, I ask them, you have the name of the company, let's say, or the entity, and you say, well, I asked them for their address information and for the names of their principals, but they never got back to me. And then you proceed anyway. Well, it ends up that entity maybe didn't get back to you for a reason. Maybe they don't exist in the way that you think they do, and that's fairly innocuous, or maybe they are on one of these lists. In which case, having their real physical address, not a P.O. box, and the names of at least their central principal or principals is very important. We understand this is not always available, but to the extent that it is, getting that information in writing and screening it against these compliance lists is a great idea. This slide is just for your resources only. This lists the comprehensive embargoes as well as the targeted restrictions countries. As I said, just as a general point in the lower box, these are the countries where you can do certain business with entities and individuals in these countries. Just make sure that you screen the people before, or the entities before going in. Okay. And OFAC has recognized the interesting and sometimes very complex situation that you find yourselves in the charitable or not-for-profit sector. Over the past 3 to 5 years, really, this has come to be very important to the U.S. government's efforts to identify and stop terrorists and terrorist organizations. Because of the countries in which you operate many times, these are the countries that are already high risk from a terrorist perspective. And so it's been recognized that you are facing unique challenges in making sure that you're not doing business with the wrong people. OFAC actually issues a risk matrix to help you work through when and if this type of compliance screening and due diligence needs to be moved up to the top of your priorities sheet. This is available on OFAC's website, and it's a handy table, actually. I carry it with me always. and really helps you, with limited resources to identify when this needs to be more of a priority than at other times. And the last thing we'll say is just what does effective controls mean? And one of the first things that the government regulators will often look to is this environment of compliance coming down from senior management? Does someone lower at your entity, your organization, have the ability to say no to a potential contractor or opportunity or partner, and senior management will support that decision? Because that person understands at that operational level that doing so would put your organization at risk. And so that's really important. And then developing policies and procedures to help make the people at your organizations aware of these risks and take steps to halt a transaction before it goes too far down the road. Employing a due diligence checklist, and that would include the screening that we're talking about, and training the people in your organization to understand these risks. I mean, this isn't, other than knowing that everybody in the campaign loves to talk about it, sometimes people don't understand the sort of practical operational effects and implications of these. And record keeping. All of these legal frameworks that we just discussed have a 5-year record keeping requirement. So looking back, if you're doing your due diligence and you're keeping it in a record, having that go back 5 years is very good business. With that, I'll turn it over. Thank you.
I want to emphasize that on the employment, your very first step to employ wisely is to make sure your employees know everything that Carrie just said. If you have employees working outside of the United States in particular, but not alone, they should know these rules. They should understand what they can and can't do. They should have a system to elevate the issues and to rely upon, as Carrie said, management to back them. It's so critically important that that is their first step. The second thing is that if you have people moving in and out of a country on some sort of regular basis, you go back to solution number 1. Make sure the organization knows exactly when it is triggering its presence in the country. And more importantly, it may be, or more likely, it might be triggering employment taxes in the country. These are 2 of the most common things that organizations do but just don't pay attention to. If you do those 2 things alone, you will make great strides towards complying with employing wisely. The third thing you should do is know what triggers being an employee in the country. And I think this is most common in the contractor environment. People, this is Carrie's point about what's the entity's name, but they can find out there's really just one guy behind there. And really you're employing a person who's given a name of a company, but it's really the person. You might be engaged in employing someone. And I will point out that unlike the United States, where there's some decent rules to guide you on who is and is not an employee, in many countries they're automatically an employee unless there's a tremendous amount of corporate structure to present that they are not in fact an employee. It's very common in Latin American countries to say, well, we hired someone to come in and clean our offices. Well, she's probably an employee and has rights to all the severance and everything else that any of your other employees have, and that can be very surprising. So I think those 3 things alone take you a long way, which is making sure you have the corruption controls, making sure you know when your employees flying in and out are triggering employment taxes, and third, knowing who is and is not an employee in the country. Besides that, I think it's very important for you to look closely at your insurance policies to find out whether your employees that are U.S. employees or other employees in the world are going into a country or actually being covered in that country. You would be surprised how insurance companies do include exclusions occasionally. Workers' comp many times has exclusions for certain types of activities which you may be engaged in that country, or countries that have some sort of sanction on them. Very important to look at that. In addition, you may actually have banking policies that affect your employees' actions in that country, where they may go there with a credit card, and that credit card has all types of limitations from your banking policies. So those are some very fundamental things to find out just because you have employees going in and out of a country. But obviously many times someone either going in from outside or someone you're working with inside does trigger a requirement that you register as an employer and therefore have a legal presence. You want to have a really good sense, and I would have a centralized control of people moving in and out, when it is that someone is not a national of the country is going in, if they have different requirements than your U.S. employees. Does someone who's coming from Australia going into Myanmar have different requirements than someone coming from the United States? Knowing what your employees' rights are. This is where legal counsel becomes critical if you're going to have a permanent presence. Labor laws vary greatly. Unionization is not uncommon, and it can be very surprising to U.S. nonprofits who intend to work in an international location. Unionization, even if it isn't in your workplace, can have large implications for you as an organization. Let's say you get a grant, lasts for 3 years. You think, I'm going to open up a business. I've invested my efforts. I've done it right. I've opened it. We have employees. And what you didn't pay attention to was the fact that you have to give them severance over 1 to 2 years after you terminate them. Or you terminate them, then the grant comes back. Maybe they collected all types of pensions under the country law, and now you're actually engaged in what the government considers fraudulent behavior for rehiring someone with a lot of expertise. So understanding how to exit a country is as important as understanding how to enter and operate there legally. So going in, having employees should be a very serious endeavor that you understand the long-term consequences. All the normal things like payroll taxes and things like that are obviously critical, but doing the background check on who you're hiring, and also understanding that data security could be very different than it is in the United States.
And can I just add one point? And this is the analysis of looking at someone and deciding, okay, are they an employee or an independent contractor? Everything Anita said is very true. And one thing that I work very closely with a couple UK lawyers, and one thing he always asks in trying to make this analysis, just from a preliminary conversation point of view, but I find that it's often very effective, is our client, the entity, will say, well, he or she is an independent contractor. This is what they do. They have expertise in this area. They're going to go out and find opportunities for me. And my UK colleague will say, well, when they hand someone a business card, what does it say? And oftentimes our client will say, well, it says XYZ organization, our organization. Okay, well, when they send someone an email, what is the email that they're using? Well, it's my organization's email. And he'll immediately say, well, then they are not an independent contractor. And so understanding whether this person that may have the expertise and may actually be, in U.S. terms, an agent of sorts, if they're only working for you and they're only sort of putting your name and your entity, your organization's name out there in looking for opportunities, then in most countries that's not going to be an independent contractor relationship. And I feel like those two questions are just really helpful sometimes to start the conversation.
And I do want to add one other thing that I forgot to mention, which is many times organizations have tremendously wonderful ethics and policies, and they'd like to go into a country and just lay that over, even if they're about ethics and not simply the law. But can be very difficult, and you have to anticipate the challenges of protecting employees that women and men, LGBT community. You have to recognize your organization will be working many times in a culture that has no legal protections for people, and that you are able to have the cultural integrity and resources to protect employees under a scheme that may be very U.S.-centric and driven possibly by U.S. law, but is not necessarily culturally expected in that country, nor you may have employees that are threatened as a result of trying to enforce their ethical rights in a country. So for employment purposes, it's not just legal issues. It can be the ethical layer that goes on top of it can be difficult for an organization. And it is to say that you should pursue the enforcement of your own policies, but recognize you may not have a legal structure that protects you.
All excellent points. And I will just say one other thing from the assurance side. I spoke with our head of global employee services last week and said, could you boil down just 3 countries for me? And I said, I work in India a lot, work in South Africa, and I work in Tanzania a lot. So what I got back on Sunday was 29 pages of jargon of just employee-related issues just in those 3 countries. So why I say that is this is probably one of the top 3 risks that any organization faces when they're doing business overseas. Some of our largest audit issues are in this exact area, over employee taxes, certainly the social taxes. Most of the time, we in the U.S. don't understand the various social taxes that are paid overseas. It is a time bomb for a lot of organizations. If you do not put the right people in place and have the right legal folks, the right tax personnel, you are putting your organization at severe risk. I can't say it any clearer than that. I could think back just in the past 5 years, some of our largest issues with my clients relate directly with this. So making sure that you have the right people looking at your employee / contractor / international work is vital. The other thing that I do want to point out on this, and this is more of a U.S. issue right now, and I have a client who just was contacted by a state. So if you have employees who work remotely, let's say you have 8 or 10 or 12 who happen to work, say, in Illinois, and your office is here in D.C., what are you doing for that as it relates to tax considerations? What's the nexus that you're trying to cover there? I have a client who is actually going through that right now with the state of Illinois, that they are not performing their tax work appropriately because they have over 5 employees in Illinois, even though they're based here. So again, just something to consider as we are working all over the world, all over the United States. Just because that person isn't physically here in D.C., there are other tax consequences that you need to think about. Treaties and bilateral agreements. Let you take that one. That's not my thing.
I just wanted to emphasize that many times people hear that, oh, if we have a treaty, it's like only 183 days. I never have anyone there 183 days. Every single country that's under some of the uniform, the model treaties, have modifications, how they calculate the days, whether it's calendar, whether it's 12 months, whether it's less than 183 days. At least one country, I believe, has 14 days in a 12-month period that can trigger your registration and payment of employment taxes. And that means your employee is paying taxes and you as an organization could be paying taxes. So it's very important that you understand what the tax treaties say as it relates to the countries in which you work.
Perfect. Moving on to solution number 5, financial controls. So, the way I like to generally start these out is everyone's heard of the fraud triangle. I think looking at the list of attendees, everybody's either legal and or financial in this room. So how I always see this is the organization actually provides the employee the opportunity to commit fraud. You open your door and allow that employee the opportunity to commit fraud. And the employee creates the own pressure on themselves or the rationalization for committing fraud. If they happen to make $200 US in Mali, and you don't have a control around paying vendors, they're going to take that money 9 times out of 10, because there's a financial pressure to do it, because they have children, they don't have food to eat, and they say, okay, if it's available to us, we're going to do it. I have probably 8 clients right now who are going through different fraud issues. I think several are actually working with the group up here. And it happens. Don't think that it doesn't happen. If you don't create a control environment that makes sure that it doesn't happen, or certainly it makes it very difficult for it to happen, it will happen. No matter the size of the organization, the one organization's about $30 million and the other one's a couple billion. And again, loose controls overseas, they will just say lost track of things, and the opportunity arose and the employees took advantage of it. Trust but verify, I know that's a canned term that a lot of people use, but there's nothing wrong with going back to the idea of kicking the tires. Do you make your employees take vacation? How this was actually found, one of these instances was actually found overseas just recently, because the person wound up getting ill. And so they had been in hospital for about a month. And there were just some anomalies that they found in the financial records. And, everyone was like, it could never be this person. They're such a loyal employee. They're always there. They've worked for the organization for 15 years. And on and on and on. And I remember sitting in a conference room and we said, they committed fraud. I have no doubt about it. And that's, the horrible side of my world of, in the assurance side, we do think the worst of people until they can, make us believe that they are good people. But that's the reality of it. But, as you're going through the controls, if you give your employees opportunity, they'll take it. 9 times out of 10, they'll take it. And how I always like to say, it all begins and ends with cash. Cash is king. Your ability to pay your vendors, procurement, ability to pay personal salaries, ability to provide subgrantee funding, all of that requires cash, whether it's the West African franc, whether it's the Tanzanian shilling, whether it's the US dollar. You're in a currency that is easily portable to other means. The ability to pay vendors and procurement, validating vendors. It's really simple. Just because there's an address on a voucher or an invoice doesn't mean they actually exist. Even Google in Mali, where I spend a fair amount of time, can tell you that there's a vendor there. You can punch in an address and you can drive by and say, you know what, they are there. Trust but verify. The too good to be true concept in procurement. I have a client dealing with fraud in this area. It was a great price on the procurement. It was a fantastic price. There was no way they could not say no. Well, come to find out, the procurement officer was getting kickbacks on the side. Validating the price of the good for the region where you purchase. I believe your USAID friends mentioned this a couple months ago. The price that I'm going to get negotiating in Tanzania is not the price that a local Tanzanian will get negotiating in Tanzania. So if you're sitting there going, I can validate this, you can't. You need to hire local resources to help you with that. But again, it's a sanity check, because all of you want to do good. Every organization in here wants to do good. Everybody wants to do good. said the auditors. We have to challenge that goodness side. But you have to understand that there are people out there who don't want to do good. And so when something tends to just not feel right, it's probably not right. Is one vendor selected repeatedly? It's the best price every single time. Well, until the procurement officer changes the procurement bid, and when you go back 3 years and you look at that and you see the whiteout on every procurement bid that they changed it on every one but the one who won, again, it brings up questions. And finally, the age-old, did it actually occur? Does the hotel exist? Did you actually have a real plane ticket? Did the training actually occur for those 300 people of which nobody's ever heard of, nor are there any records of ever happening? The ability to pay personnel salaries. Life example. Does the employee exist? Have you seen him? I have a client who dealt with, they had 20 employees outside of the area. None of them existed. The HR director made them up. It was a nice little chunk of change in their wallet, but yeah, nobody ever thought to actually every once in a while go out and say, hand out a check. You exist. Great. And again, this is just common sense things that you can do in your offices to add a little bit of fiduciary control in your day-to-day operations. Time records. I have a client until 2 years ago had their pay rate or their timesheets pre-populated between 4 different projects. It's not a problem, right? Sure, they were working 25% of their day on every single client. No issues there. Involvement of senior executives in the HR process, or lack thereof. I'm too busy for this, and having their administrative assistant sign off on the sheets where people get paid. Shocking that went on for 2 years, but no one ever picked that one up. Do your job, and you should help alleviate some of that. Salary change approvals. Is it board driven? The subgrantee funding, this one we could go on and on and on all day long. How do you validate what your subgrantee is telling you? This is the lowest hanging fruit out there. You get a financial report, you stamp it, received, signed off, done. And then your donor comes back and says, well, show me what you did. Did the personnel really work on the project? How do you know that your subgrantee employees worked on it? They don't have timesheets because you didn't make them do timesheets when you were setting up the initial internal control structure. Did the training, again, events, outreach really occur? Do you ever do spot checks? They say they're going to do this. Do you ever do a spot check to make sure they actually did it? And the age-old, easy low-hanging fruit again, did the number of patients or trainings, et cetera, actually occur? This one I've seen probably 20 times at least. The low-hanging fruit for any organization, and I could tell you a story behind every one of these. In the interest of time, I won't. But I do want to just point out a couple of these. The performance of bank reconciliations is important. Doing it monthly is important. As someone had said a little earlier today out in the audience, for some organizations, doing it daily based on how bad their controls are probably would be okay. IT controls work if you let them. I mean, passwords for computers really do work if you don't share them with everybody in the office, which I have clients who have them hanging up in case somebody's sick. That way they can all access the same system. Yeah. Perform vendor checks on a regular basis. Here's a novel concept. Have your organization have access to the bank account and not just the controller. Think about that one for a second. That's real life right there. That happened. How do you keep data records? Altered documents should be challenged. When the piece of paper weighs 5 pounds from all the whiteout that's used on it to alter it, you might want to question it. Photoshop is incredible. In Nairobi, there's 4 streets that all they do is Photoshop fake invoices and vendors. They do beautiful work. You'd never know it unless you challenged it. And then finally, challenge your whistleblower policy. It's amazing when clients put in good whistleblower policies and have a very strong tone at the top, both at the top I'll use the example of Washington, D.C., but also at the top in your field offices or your remote locations here in the U.S. It's amazing what you find when people are driven to do the right thing. So again, just challenge those whistleblower policies occasionally and make sure you're having your employees think about why they're doing them. And finally, our Treasury Department has some very real interest in a lot of financial controls too. And so you want to make sure that you're considering these forms that are behind me when you're looking at your financial controls overseas as well. Oh, still me. Okay. So compliance with funder requirements. And so funding sources vary. Institutional and government, I've mentioned a little bit. Generally, there's significant strings attached to that money. Personal and country donors, my one word of advice would be, what's their ultimate intentions? Be careful when you accept that money. Membership, this is something that a lot of my clients are struggling with right now. What's the membership really worth? What's that advocacy worth as those membership roles continually seemingly decline for a lot of organizations? Events, I don't know about many of your organizations. Quite a few of my organizations are really struggling with event income. A lot of people go to a lot of events and they don't seem to have the value they once did. Certainly they cost more to do and you don't get as much money out of them. The sales of products such as publications, I'm not going to ask the question, but the last time I did a presentation on this, I think I had 3 people raise their hand who'd actually read a magazine in the last month that's not on an iPad, a Samsung, hopefully not 7. And so again, the world's changing. This is easily, readily available anymore. People aren't going to pay for it. And then finally, sales of services such as certifications and such.
And I think if I could, just a moment, this is a great slide to jump in and bring back to the FCPA compliance considerations. And looking at your funding sources and whether or not, I think Matt briefly alluded to this, but is there a quid pro quo that you need to worry about with respect to receipt of certain funds in country? Who is the funder? Performing that due diligence from a what, where, how reputational perspective, and then understanding whether receipt of that money means that there's something expected in return, or that you would be providing something to that funder, first off, in order to get funding or an opportunity to, take part that's in something that needed a permit, for example, in a country. All of these types of quid pro quos don't have to have the currency exchange to raise a concern.
That's an excellent point. So donor activities, these are the folks that I deal with on a pretty regular basis. All do amazing things for a lot of people globally. Better? Sorry. However, they, to use the old Ghostbusters analogy, they expect results, and they want to understand those results. So there's increasing demand for transparency of the organizations who accept those monies. What are they getting for their money? Access to your books and records. We certainly have seen a continued focus on focusing on their piece of the program. It really doesn't matter what else you're doing. What about their program? What about their portion of the funding? How does that really impact them? And just in the interest of time, I'll move this forward here. What we've seen in the past 4 years is really an explosion. There's no other way to explain it. It's just an explosion in donor-mandated specific grant audits at very low thresholds of materiality, a lot of very specified, agreed-upon procedures, which from an audit perspective, we're going onerous, very onerous, but also from your perspective, that costs money. There's just no other way to put it. Those cost money. We tend to travel a lot for those because they want them done in country. So, the one area that I would say is they're looking at the letter of the law. So certainly for those of you in here from the program side and from counsel's office, you want to make sure that when you're negotiating those terms of reference, that you understand what they're asking. Those audit requirements, they're no longer perfunctory, and they're no longer, we'll get to it. I have a client right now who is being told if they do not get this audit done, they want $200,000 refunded. End of this year. And the donor was like, we're done messing with you. You signed the agreement. You're going to do it. And then finally, things to consider. The one I want to say is the second bullet point, understand the cost of what you're getting into. What's your overhead rate? As we all know, a lot of the donors won't pay overhead or very little of the overhead. And then finally, from an organizational standpoint, and we talked about this a little earlier, some money is not good money. And that's really hard for organizations to step back and not take the money. Some money is not good money. And you need to understand organizationally if you can perform and what your wherewithal is when you receive those funds.
I just want to add one more thing, which is, and going back to our September program in particular, donors are talking to donors, especially institutional donors. So if you get crossways with one, you could be crossways with many. And it cannot be emphasized enough to understand what the letter of the law is within that agreement, because even if that is not the same term as is in the next one you have, once you start becoming crossways, you will be called upon by others. And this is increasing, especially with public funding around the world and multilaterals.
Absolutely.
All right, so in the interest of time and to ensure that we can get to some questions if there are any, I'm not going to spend too much time on these next slides. But solution 7 is to raise the awareness on looking at your organization's intellectual property. And I always like to say two things about this. The first is this is really going to be something that varies depending on where you're doing business. There are certain countries around the world where your intellectual property may be very much at risk the minute you step foot into that country. And that's because of the environment in that country. Let's take China as an example, but also because of China's laws. They're a first-to-file country for trademark purposes, and so there's not a use provision necessarily like there is under U.S. law. And so not only is a country like China, it's developing rapidly. There are lots of organizations and entities that want to take any opportunity they can to get rights, but it's also a first-to-file country. And so looking at those types of factors for each place where you're doing business is the first step with respect to IP protection. Where do you need to put your resources and focus from a priority perspective? And then the second thing I would always say is just differentiate between your IP. There's confidential information, business proprietary information, then there's your trademarks and your copyrights. I think we have several lawyers that are kept full-time busy by Jeff's clients in this world. And so giving it just one slide does it a bit of disjustice, but it is very important and is also complicated. And so if you do have questions, be sure to raise them and identify the marks and the copyright and the materials that you may want to copyright that are important to your organization and the continued viability of your organization, especially in the educational and networking sides of things.
Just a couple corollary points to make. First off, not just China, but most countries around the world in terms of trademark protection are, like Carrie said, first to file, meaning there's no common law trademark rights like there are in the U.S. that you get from usage alone. Whoever gets to the filing desk first is the one who generally has superior rights. And so anytime you're starting to work or already are working overseas in different countries in virtually any capacity, you really want to look right away at potential trademark registrations. Unfortunately, it's not a simple, inexpensive process. We work, for instance, with an organization called Project Management Institute that maintains registration for their certification mark in over, I think, 250 countries around the world. It's a very big project to do that and to maintain it, but it's critically important for them and for all of you. Another thing to keep in mind, make sure you understand the differences between trademarks and copyrights. They're very different forms of intellectual property, subject to different ways that they can be protected and or infringed in different countries, and you need to understand that. Copyright registration is another way to help protect your rights, but you also have to look at other things, such as, is the country in which you're operating one where it really doesn't matter what registrations you have because it's just ripe for infringement? And China is perhaps, unfortunately, a great example of that, and many of our clients are dealing with that challenge in China. But you also have to look to, who are you contracting with? to help carry out your programs in those countries. Make sure, just like you have good provisions in there dealing with the flow of money and everything else we're talking about here during this program, also make sure you have good licensing provisions in there that spell out the terms of the trademark and/or copyright licenses that you're providing to those folks. What rights are you providing? What rights are you not providing? What are you prohibiting them from doing? What happens if the agreement terminates, which it likely will at some point, making clear they have no rights to use those copyrights or trademarks beyond that. All of that can go a long way toward protecting your IP.
Those are great points, Jeff. Thank you. And we'll talk a little bit about the licensing and IP contract provisions on the next slide as well. And just one final point on this is I would say that, in looking at your portfolio and all of the different places where you're doing business, it may be that there's one country that stands out with respect to some of the risks that Jeff just went through. But if you're doing business in other countries, it's worthwhile to ensure that you're looking at those too, because it could affect your rights to use those materials worldwide. And so it's all interrelated. Okay, and so next, this is a great segue into looking at important contract terms and conditions. Unfortunately, a lot of times we go into opportunities overseas full of enthusiasm, hope, and optimism, and we enter into contracts and then it doesn't go so well. And so making sure that the contracts that we enter into have precise, specific language that deals with certain types of issues, and most importantly, a clear termination provision is really key to protecting your organization. And we could, again, go on and on about these types, about the most important ones that we've seen over and over in our work, but we highlight a few here. Jeff already pointed out having firm IP and copyright language, setting forth whether there is a limited license or use of that IP and copyrighted materials in your contract, protecting your confidential information likewise in a provision, very, very important. But we'll go to the top of the list there and start with dispute resolution. Oftentimes, the first thing we'll see in a back and forth contract negotiation is a contract that comes back from your overseas partner or an agent, and it says, the local court of, Jakarta, Indonesia is going to govern this, this contract. Any dispute will go there. We don't recommend agreeing to that. However, what we've found is that it's really difficult to come back and say, nope, Washington, D.C. Your overseas partner is going to equally say, we're not agreeing to that. What we have found is an oftentimes happy medium, and one that is binding, neutral, and protects you from an international convention perspective is looking at arbitration fora around the world. And due to international conventions, specifically the New York Convention, that's the colloquial term for the convention under the UN that over 145 countries have signed, is a good opportunity to find a forum for enforceable decisions that are binding to your organization. A lot of times court judgments are not enforceable outside of the country in which they are entered into. The opportunity to go to a neutral forum would also include looking at the different arbitration rules that you might be able to use, the rules of the International Chamber of Commerce, the ICC rules, or the London Court of International Arbitration, often called the LCIA rules. And finally, the International Center for Dispute Resolution, the IDCR rules, are three that we often see. And going into your negotiations with this as an option for your dispute resolution is often one that helps the parties, reach an agreement. Making sure that your governing law, whatever it is, excludes a conflicts of law provision, so that is the governing law that's in your contract is what actually will apply should a dispute arise. And making sure this seems sort of obvious because so much of what we do around the world is in English, put it in your contract. Say that any dispute resolution or certain auditing or, you name it, amendments to the contract all must be in English. Most parties will agree to this, but if you don't have it in your contract, that's sometimes something that comes back to bite us, and we end up having disputes over interpretation of a translated agreement or memorandum of understanding or something like that. We talked about agency versus independent contractor. Now, whether or not at the end of the day it gets interpreted this way, we would always recommend that you have independent contractor language should it be applicable to the situation in your contract. This is the first line of defense to enforcing that structure on your relationship with your overseas partner. We talked about IP, and then performance-based measurable outcomes, setting forth oftentimes in a schedule or a statement of work that is attached to the contract, but setting forth the obligations of your organization and your partner's organization. Put them in writing, not we're going to both strive to do this really well. Without specifics, and that's oftentimes what we see. But setting forth some specifics is really helpful. Flow down provisions for funders, and as I said, it's easier to get in than it is to get out. So termination provisions in writing.
I'm not going to belabor pay the tax man because we've mentioned it several times, but I do include some specific reporting requirements to the IRS that can sometimes be overlooked while you're doing a great job in country. I'll just want to make my last point about insurance. I've already made a reference to taking a close look. I would say it's important to talk to legal counsel about the advisability of also having insurance purchased in country. Many places, that's a better place to start depending on the circumstances. I would also regularly stay abreast of the cultural, political, economic conditions in the country and how it relates to your insurance policy. Many insurance policies create exclusions under certain circumstances, and those circumstances can be happening at a time when you're not keeping your eye on the ball. So having someone who's connected to both the insurance and the local activities, I think that's particularly important in today's world environment because there's so much influx. Identify what persons are at risk in that country and make sure all of them have some sort of coverage or your organization is covered. Volunteers in many countries are immediately employees, going back to an earlier point, but assuming they're not, being very cognizant that while you may not make representations to them, your organization could be exposed. So having a really strong insurance analysis process is critical. And with that, any questions, Jeff?
Okay, any questions for any of our panelists here today? And while you think of your questions, one, Matt, for you, given the increased interest by funders for organizations to conduct audits, talking about granting organizations, and we're presumably talking about private entities, not public entities, do you see such costs being accepted in a line item in the grant agreement? Basically, are you seeing an ability to get the granting organization to pay for that, or are those bills generally having to be paid by the grantee?
Generally speaking, shockingly, the donors have been willing to pay for it, except in very rare circumstances, and those circumstances are where it wasn't built into the initial contract. But again, understanding your contracting process, just making sure that if they're saying an audit, you do need to say who's going to pay for that. But they are willing.
And Matt, in these audits, I know you've conducted quite a number of them, what are some of the most common problems that you're finding? And let's put kind of fraud and embezzlement aside. But beyond that, what are some of the other most common problems that you're encountering? And then what's been, if you're aware of it, kind of how have those issues been resolved?
Common cost allocation is definitely one of them, on how the country-specific costs are coming across, especially when there's not a strong time reporting mechanism, which is how many of the organizations allocate things. The other is going back to the low-hanging fruit, just not adequate support. Documentation. If nothing that's come out of all of this, you have to document why you're doing things. One of the issues came up actually was the anti-bribery, and it was through on an agency transaction for one of the subgrantees, and they had no documentation on why an official had been involved with this whole situation, and so that was raised as a point. So again, it's just following the paper trail, making sure things are being put where they are. But certainly when you're getting down to the materiality levels of a program grant specific audit, your documentation really needs to be enhanced in most situations.
Okay. Another question from the webinar: when you're dealing with subcontractors and subgrantees in various countries, and sometimes you're dealing with multiple layers of subrecipients in that regard, what are some practical tips to ensure things like anti-bribery and anti-corruption compliance?
Well, a couple of things. One is key to have it in your agreements and it's required flow down. The other thing is to have your organization have a very strong subrecipient monitoring program where you have staff and auditors that are specifically dedicated to that, whether in-house or outside, that do actually follow the money. I think those demonstrate, even if you're not looking at every dime, that your organization has a systemic process for evaluation. And to do it not just with public money but with private money as well, so that you have can reflect that it is an organizational priority.
And I would just add from a practical perspective that we find just requesting a simple certification of compliance for anti-bribery purposes, like we call it an FCPA certification. I mean, half a page with a signature from your principal agents and contractors, and so that they know they have signed a piece of paper and given it back to your in-country office. They have some level of responsibility and obligation there. That tends to help push the envelope and the ball down the road a bit in ensuring that they pass that on in the work that they're doing in country on your behalf.
Carrie, something to add to that? Carrie, I know you and I and another colleague are doing some training tomorrow, I think, for a client on some of these issues for their U.S. staff. A lot of the things that we've talked about here, and even presentations like this, a lot of the tips that Matt gave and all of you guys gave on procurement and everything else while operating overseas. What are some effective ways that you found that our clients or others are using to train their folks? Obviously it's very difficult to fly everyone to the States for in-person training, although we've certainly found that in-person trainings are the most effective by far, and a lot of these recorded videos that you could force employees to watch or others are not nearly as effective. Most people fall asleep more than less than halfway through. So what are some other techniques that you guys have found to push down some of this really critical training of employees, of contractors, and others overseas?
Great question. So first of all, I think one of the primary questions I get is, this seems like it's going to cost too much money and take too much time. How do I prioritize? We'll talk to organizations and they say, well, we're already in 84 countries. And so what we would first say is do a risk analysis. Look at the Transparency International's index of the most corrupt countries in the world and decide if you're in any of those. And so, first just, make your priority list. Second, what we often say is, to the extent it's possible, the head of your operations in those countries, as a starting point, it would be great if there is an in-person training opportunity. So to the extent that they're all coming in for a big event in the United States or a board meeting or something like that, that those heads of operations receive the benefits of the in-person training, the back and forth, the questions. I think our Q&As are often when most of this gets fleshed out and you realize where the questions and the potential issues may lie. And then it's the train the trainer. We often can provide tailored training materials so that person goes back, and the people that are the touch points for dealing with in-country service providers and potentially foreign government officials or partners, the heads of operation go back to those countries and they can provide an overview of the training materials and the training presentations. And so there's at least someone who knows. And what we often say too is, just call us to the extent that we provide you some training resources, but a specific question comes up. And finally, and this sounds really sort of pedantic, but quizzes. It's a great way to make sure people are paying attention, but at the end of the day, putting together a couple questions that go to the practical day-to-day operations of your specific organization and asking people how they might be handled is a great way to get people thinking about these compliance requirements.
And I would second everything you just said, and especially train the trainer, tone at the top, but rolling that out on a regional scale. If you have a segment that happens to be, in Eastern Africa, Western Africa, getting it into the right hands, and then the questions, I think, are incredible because you put it into their thought process on what they do daily. You're not preaching at them. You're trying to give them a real life scenario of how to deal with a situation, and you can take that to any level, but it's critical.
I'll just say one more thing, a nod to the Nature Conservancy. They do actually use real case studies, and they do monthly case studies, plus it's incorporated where the tests are based on real cases, so staff can see it happening in real life, and it's a really effective way to make it real.
Okay, question in the back. Wait, just wait for the mic.
A real-life question and directed to Carrie. In the sense that you're dealing with these various international arbitration bodies, in your experience, is there one that is more efficient, more cost-effective than the others? Because we see them a lot, but we've never had the opportunity to use one.
Unfortunately, I'm going to give a little bit of a lawyerly answer, which is that it depends. and it depends on a variety of factors. I would say generally speaking, so the three big sets of arbitration bodies I named are actually the rules that would be applied. And so there are forum and then there are rules. So the ICC, the LCIA, and the IDCR are the rules. And so you can look at, where and how those would be implemented. I find that the ICC is most often used. The IDCR is part of the American Arbitration Association, so very well known here in the United States as well. But it depends on, I think, who the parties are, what countries are at issue. And so, unfortunately, there's not a clear winner, so to speak. And, I would say that depending on which set of rules you may be looking to, another thing to think of is where, just geographically you'd want it to take place. It's not supposed to matter, but sometimes it does. So that would be, hopefully that answers your question at least a little.
Right here, one more question, and then we're going to have to wrap up.
Great, thanks guys. Quick question going back to this independent contractor versus employee model. Within an AMC or an association management company, let's say that a question that I'm getting quite a bit, let's say that we have a client or a nonprofit or a charity who's abroad. We've signed the contract. The AMC is actually abroad in another country as well, and then later on the line takes additional services in the form of, let's say they want to hire a creative designer or somebody to go and host an event. And like you said, when you hand out that business card, it's now a subsidiary of the company. Does this get into an employee, and are they covered under the contract that was previously negotiated, or do they need an additional contract with the same provisions?
I hate saying this over and over. It sort of depends. So I would say, and please feel free to jump in, but that initial contract is important, and exactly what it says is going to be important. But it may not be cured by entering into a second one in certain countries, and depending on the relationship. There are certain countries where just wherever you sign the contract, that's what governs. That's the governing law, just depending. So I'm not sure if you have anything to add, Anita. I mean,
it's a multifaceted question, and it has some of the same analysis you would have. Was that person really dependent on that income? But really, in those countries, many times what they're very interested in is the employment tax collection. And that may be an acceptable thing, even though it doesn't create any additional liabilities. So it depends also on the environments the legal environment's motivation. Let's say that.
Okay, well, I want to thank everyone for attending today. I want to especially thank our panelists. It was a real challenge to find a date on Matt's schedule where he was available and in country to be able to do this. So we were able to nail him down one time for lunch to plan it out and one time to do the program. But thank you, Matt. Thanks for BDO for being a great co-sponsor, and thanks to Carrie and Anita for a terrific job. Everyone have a very happy holiday season, and we'll see you back here in January. Thank you.